Hello, and welcome to our data protection webinar on marketing and compliance. I'm Tom Llewellyn, a commercial litigation and data protection partner, focusing more on the contentious side of data protection. And joining me is Hannah Pettit, who's a commercial and data protection associate, focusing more on the advisory side. Couple of quick housekeeping points. Just a reminder that this is being recorded. Also that due to time constraints, we won't be having a Q&A session at the end. But if you do have any questions, please do feel free to contact myself or Hannah to discuss or raise any questions that you might have. In terms of the agenda for today, we're going to be looking at law and compliance requirements, which Hannah will focus on, and then I will look at this through the lens of non-compliance and ICO enforcement with an eye on practical learnings to take from some recent decisions. And with that in mind, I will now hand over to Hannah.
Thanks very much, Tom. So I'm going to start by giving a bit of an overview of the legal framework for direct marketing in the UK. To hopefully then help you navigate which marketing activities are compliant and which aren't. So when we use the term direct marketing, what do we mean by that? Now, direct marketing is defined in the Data Protection Act 2018, and that's that definition set out on the slide there. So it's the communication by whatever means of advertising or marketing material which is directed to particular individuals. Now, this covers any communications, so it could be emails, text messages, telephone calls or post. And also, specifically, these communications need to be directed to a particular person or category of person. So this covers personally addressed post, it covers emails to a particular email address, and also, interestingly, it covers online advertising that's targeted to a particular user. So, for example, because of that user's browsing or purchasing history. What it doesn't include is leaflets, for example, that are delivered to all all houses in an area, or maybe an online advert that's on a website for everyone viewing that website. One type of communication that I wanted to quickly touch upon that it's particularly important to distinguish from direct marketing is service communications. And this is because service communications are not subject to the direct marketing rules. So it's really important to remember you don't need to think about things such as marketing consent when you're sending these service communications. So service communications are any communication which is sent for customer service purposes, perhaps administrative purposes, or also for performance of a contract. So a couple of key examples there are maybe reminding somebody about an appointment or responding to an inquiry that they've submitted via your website Contact Us form. So what are the rules around direct marketing in the UK? Now, the key pieces of legislation that govern direct marketing in the UK are these three pieces set out on the screen. Now, this is the framework that governs the kind of routine course of business marketing by the vast majority of organisations. There are some additional codes of practice, industry codes of practice and pieces of legislation specific to particular industries, but I want to focus on these core pieces of legislation that are applicable to most organisations. So looking to start with at the Privacy and Electronic Communications Regulations, and these are often abbreviated to PECA. Now, this is the key piece of legislation which sets out the marketing rules, and you'll hear Tom and I refer to PECA throughout the rest of the webinar. So that sort of sets out the various rules. But it's also important to remember both the UK GDPR and the Data Protection Act 2018. And that's because direct marketing is the communication of marketing material which is directed to particular individuals. So it also involves the processing of personal data. And that means that any of that processing needs to comply with UK data protection laws, which, the key items there are the UK GDPR and Data Protection Act. Now, just one example, obviously, we've got lots of data protection compliance requirements under the GDPR and the Data Protection Act. But just one key example is that you need to have a lawful basis. If under PECA, you're relying on consent for a particular marketing activity, and we'll talk a lot about consent throughout the webinar, but if you're relying on consent under PECA, it follows that consent will be your lawful basis under the UK GDPR. Whereas actually, if you're not required to get consent under PECA, you'll then be looking at an alternative lawful basis under the GDPR. So, for example, your legitimate business interests in promoting your products and services. So now what I'm going to do is explore those specific direct marketing rules under the Privacy and Electronic Communications regulations. So the rules differ depending on the type of marketing you want to carry out, and also whether you're sending it to an individual subscriber or a corporate subscriber. So I want to start by just setting out the difference between individual and corporate subscribers, and then I'll dive into the different types of communications and what the rules are for each. So Regulation 2.1 of PECA sets out the definitions for each of these terms, which you'll see on the slide there. Now, an individual subscriber is any living individual, and it includes an unincorporated body of such individuals. So importantly, this captures sole traders and other unincorporated organisations, and it isn't just consumers. And if we then look at that corporate subscriber definition, effectively, this is a corporate body with separate legal status. So it includes companies, limited liability partnerships, and also some government bodies. And when you're contacting an employee at a corporate entity using their corporate email address or telephone number, that's going to count as contacting the corporate subscriber for the purposes of PECA. And that's because the subscriber is their employer. So you're promoting your goods and services to their organisation rather than to them as an individual. So if you take my Ashford's email address, for example, when I receive marketing communications at that email address, I'm considered a corporate subscriber. So with that in mind and the difference between individual and corporate subscribers set out, I then wanted to dive into the different types of marketing communication and the different rules that apply to each. So we'll start with marketing calls. Now, live marketing calls, these are where somebody is speaking live on the other end of the phone. So exactly what it says on the tin. And this is governed by Regulation 21 of PECA. And the rules here apply in the same way to both individual and corporate subscribers. So the rules are exactly the same for both categories of individual. Now, the basic rule here is that you can make live marketing calls if there's no objection to the call. So the recipient hasn't asked you not to call them. And also provided that the recipient hasn't registered with the telephone preference service or the corporate telephone preference service. Now, what's really key here is keeping your own do not call list, and you're screening against that every time. So making sure that you're recording anybody who objects to being called and check that you don't call them. And then also doing that screening process against the telephone preference service and corporate telephone preference service, because both of those operate as central opt-out registers. So they need to be actively checked as well. Now, the kind of key thing to remember here as well, and it links back to that difference in definition between individual and corporate subscriber, is that actually some businesses, for example, sole traders, they're going to be registered with the telephone preference service rather than the corporate telephone preference service. So if you're carrying out business context marketing, you're not sending marketing to consumers, then some of those recipients may be sole traders, and you do still need to be thinking about that telephone preference service and not just the corporate telephone preference service. Now, just to briefly mention, there are some additional rules that apply to live marketing calls if what you're marketing is claims management services or pension schemes. And those additional rules cover things like requiring consent from the recipient before giving them a call. But I'm not going to dive into those specific rules now, just because they're very sort of nuanced and they're very specific to those two contexts. But the main takeaway here is that if you are sending marketing for claims management services or pension schemes, the basic rule set out on the screen here that you just need to make sure the individual hasn't opted out or registered with the telephone preference service won't apply, and there is a higher threshold. So how do the rules then differ when we're looking at automated calls? So automated calls are governed by Regulation 19 of PECA. And again, this applies to both individual and corporate subscribers in the same way. And the rules are a lot stricter when it comes to automated marketing calls. And ultimately, that's because they're considered much more intrusive. So you can only make an automated marketing call if you have the individual's consent. And as soon as that consent is withdrawn, you have to stop making that marketing call. So As a result, there's not going to be any need to check that telephone preference service or the corporate telephone preference service, because it's simply a question of whether or not you have consent. Now, I wanted to just wrap up this section on marketing calls with a few additional pointers, which are going to apply regardless of the type of marketing call that you're making. So whether or not it's a live or automated call. So key additional takeaways are: you must always display your number. And I think organisations are actually becoming much more aware of this requirement, because I found in recent years that a lot of marketing calls I receive now do tend to always include their number, whereas a few years ago, I would say majority of marketing calls I received from withheld numbers. You must also say which organisation you're calling from. And as well as saying what organisation you're calling on behalf of, give them a free contact route, so either an address or a free phone number. And then the final thing just to always keep in mind is that marketing call likely to cause distress? So some of the key things to be thinking about are, are the recipients elderly, potentially vulnerable? What time of day are you calling them? And also, if you're not getting, if your call isn't being answered, it's about not pestering that individual with lots of repeated calls, because obviously that would be potentially distressing. Now, that concludes the section on marketing calls, and we'll next move on to electronic marketing. So when we talk about, electronic mail marketing, we talk about examples being emails and texts. And this electronic mail marketing of emails and text is governed by Regulation 22 of PECA. And this, unlike those rules around marketing calls, only applies to individual subscribers. So this framework that I'm about to set out isn't going to apply to corporate subscribers. So the first rule here is that you must have consent to send electronic mail marketing to individual subscribers, unless the soft opt-in applies. Now, that consent must be freely given, specific, informed, and unambiguous. And that means in practice that the individual subscriber must have taken a positive action. So that's why we talk about actively ticking a box. So taking that positive action, and it's not going to be enough for them to untick a box to opt out. They need to be actively opting in. And when we talk about specific consent, it needs to be really clear what that individual is consenting to. So they need to know who they're consenting to receive marketing from, and also what type of marketing they're consenting to receive. And this is something that Tom's going to look at in a bit more detail. But importantly, they need to be clear whether they're consenting to receive, for example, text message marketing, email marketing, or both. Now, the exception that I've mentioned to this consent requirement for individual subscribers is the soft opt-in. This is really useful for a lot of businesses, but it does apply very narrowly. And there are 5 distinct requirements which are set out on the slide there. And all 5 of these requirements need to be met in order to rely on the soft opt-in. So firstly, you must have obtained the contact details from the individual themselves, not from a third-party source. The recipient must have purchased a product or service from you, or actively expressed an interest in buying your products or services. So examples being if they'd asked for a quote, or if they'd asked for more information about your products or services. But it's not going to be enough that they were simply browsing the products on your website, or maybe that they made a general inquiry that didn't relate to your products. They must be actively expressing an interest in purchasing. Thirdly, then, what you're then ultimately marketing to them needs to be similar to what they originally either purchased from you or inquired about. So quite like the example here of supermarkets who have a really broad range of offerings. A supermarket can't rely on the soft opt-in to promote, say, wider banking products to its groceries customers. They can only rely on it to promote groceries to their groceries customers. So it's quite a nice sort of example there that a lot of businesses can then replicate for their own offerings, products and services. Fourth, then, you must have given an opportunity for individuals to opt out when you first collected their contact details. So this would be primarily through an opt-out box on the relevant contact form or the relevant checkout route, asking the individual to untick the box if they don't want to receive marketing. And you note the difference there, that rather than asking them to actively tick the box, which you would do if you're asking for their consent, you ask them to untick the box, so opt out. And finally, in every subsequent communication, you must give them the opportunity to opt out. So this is going to be unsubscribe links that we often see in emails, text messages, you often see wording which says text this number to say stop if you want to opt out. it's providing those easy opt-out routes. And I would say the area that marketers most often fall down on is that fourth requirement, and it's providing the opportunity to opt out when details were first collected. And if you don't provide that opt-out opportunity on that first contact point, so, you know, when somebody signs up, when somebody first makes a purchase, you've then missed the opportunity to rely on the soft opt-in, because you can't rewind time and reintroduce the opt-out when you first collected their details. So it's really important to think about that as part of your sign-up routes. Now, I'll really quickly finish the electronic mail section with a quick look at the rules for email and text marketing to corporate subscribers. Now, as I mentioned at the start, Regulation 22 of PECA doesn't apply to corporate subscribers, which means that you don't need consent. Sorry, I'm just going to click back through to the right slide. So you don't need consent for sending marketing to corporate subscribers, and you don't need to worry about the soft opt-in either. But the data protection legislation does apply if the contact details that you're using contain personal data, so a name. And this means that you need to make sure that you won't be reliant on consent, so you need to make sure that legitimate interests apply in the context. And then importantly, it's including that unsubscribe route as well. And then finally, just a quick summary of postal marketing, because I just wanted to flag here that postal marketing is another area that's not covered by PECA, and that's because the focus of PECA is electronic communications. So any postal direct marketing will only be subject to the UK GDPR and Data Protection Act, and again, that's to the extent that they contain personal data. So for example, if they're personally addressed to somebody. When you're sending postal marketing that's addressed to someone, you just need to think about these key 3 things on the slide. So make sure you've got a lawful basis under the UK GDPR, check that the individual hasn't opted out, check your do not contact list, and also check the mailing preference service. Now, that was a whistle-stop tour of direct marketing compliance rules, and I'm now going to hand over to Tom, who's going to focus on the ICO's enforcement action in this space.
Thank you, Hannah. So I'm not intending that this section is going to try and scare people into compliance. Rather, I want to look at and demonstrate where some businesses and charities have come unstuck, how the ICO has viewed different conduct, and what practical lessons can be learned. But I thought it's first helpful to have a quick look at the ICO's role and powers in terms of marketing enforcement. And so, as I'm sure everybody knows, the ICO is the kind of independent supervisory authority for data protection law and PECA in the UK. In terms of marketing enforcement, its tools include assessment notices, warnings, reprimands, enforcement notices, and penalty notices or fines. And really, it's the latter two, enforcement notices and penalty notices, that we see most of in relation to marketing activity. Now, the maximum fine under PECA is currently £500,000, and it can be issued against an organisation or its directors. Now, PECA fines can be used in conjunction with fines for general UK GDPR and data protection infringements. As a reminder, those fines can be up to 17.5 million or 4% of annual worldwide turnover, whichever is higher, which is obviously significantly higher than under PECA. It's worth noting that the Data Protection and Digital Information Bill that was going through Parliament prior to the general election, and which wasn't passed and has fallen to one side at the moment, did include a provision for making fines under PECA level with that data protection breaches. But at present, there's no indication that is going to be back before Parliament anytime soon. So for now, the limit is 500,000. And really, it does seem that the ICO is sticking to that fine limit rather than trying to shoehorn other breaches of GDPR in to increase, the fine level substantially. So what is the ICO's approach? Well, it takes a risk-based, effective and proportionate approach to enforcement. Substantial fines are typically reserved for spammers, rogue telemarketers, and really egregious examples. However, the ICO has been very clear that it will take action when there's been a breach of PECA, and enforcement will have a maximum impact. And in that regard, what we really mean is where it will kind of perform a wider deterrent rather than just necessarily punitive for the business that has kind of breached the regulations in any given instance. So now we're going to look at a couple of kind of comparative examples to see how the ICO has actually approached matters in practice. So the first example is the recent example of HelloFresh, which I know as a company we'll all be familiar with. I've chosen this because it shows that, even with the best intentions, reputable companies can get it wrong and end up facing a significant fine. In this case, a fine of £140,000, the breach of Regulation 22, which, as Hannah pointed out, relates to marketing messages. Now, it came to the ICO's attention because there were 15,000 complaints lodged with the UK's spam reporting services, which is a telephone number 7726, where if you receive a spam text message, you can forward the message to, and it will compile the data that will then pass to the ICO. 7726 actually spells out spam on your telephone keypad, and it's a very simple way to kind of forward messages. The 7726 passed information to the ICO, and the ICO opened an investigation into HelloFresh. And just a slight warning there that, a misplaced marketing campaign, can actually quite easily lead to an ICO investigation if it results in a high number of complaints. Just a point to be aware of there. Now, in this instance, there were 1.1 million text messages delivered to active and unactive customers, followed by 80 million marketing emails. HelloFresh had separated customers into two groups: active customers, which were current or paused customer or subscriptions, and reactivation customers, which were those who cancelled within the last 24 months but consented to receive marketing messages. And it's the latter group that the ICO investigation focused on. HelloFresh asserted compliance. For example, it asserted that it checked a phone number against a marketing preference list and removed customers within 30 days of a removal request being made, which on the face of it would seem compliant to the regulations. However, preference settings did not allow users to set their marketing preferences by reference to the specific communication channel used, and there was no information about the length of time that inactive customers would receive marketing for. HelloFresh provided the ICO with evidence of consent, but the ICO did not agree that there was sufficient sufficient compliance with the regulations. So the ICO held that for consent to be valid, it was required to be specific to the type of communication received and the organisation sending it, and consent will not be informed if it is not clear what is being consented to. So in this instance, it was held that there was a breach of Regulation 22 of PECA because the consent statement did not mention text messages would be used as a channel for direct marketing. The consent statement was bundled with consent to receive free samples and an age confirmation statement. And there was insufficient information about the fact that marketing messages would be received for up to 24 months after cancellation. Due to the volume, and we're talking 81 million messages in total here, it was deemed to be serious, but not deliberate. And HelloFresh hadn't intentionally set out to breach PECA. That said, the contravention was negligent, as due care was not taken, and importantly, the ICO took the view there was sufficient guidance for HelloFresh to be aware of its responsibilities. Ignorance is not an excuse, is the message from the ICO there. The ICO then held that HelloFresh also failed to take reasonable steps to prevent the contraventions, which in this context meant ensuring that the consent statement, or a failure to ensure that consent statements had been reviewed against guidance from the ICO, not allowing marketing channels to be easily selected or deselected, not including marketing information relating to direct marketing in privacy notices, and not having sufficient internal policies and training methods to ensure compliance. So how was a fine of 140,000 arrived at? Well, as I say, HelloFresh hadn't deliberately set out to breach PECA. There were no aggravating factors. HelloFresh cooperated, has taken steps subsequently to improve its practices, but the contravention was serious and negligent, and there were not reasonable steps to prevent it were not taken. And as well, linking back to what I mentioned earlier, the ICO mentioned in its decision that the level of the penalty was also intended to act as a wider general deterrent against non-compliance with PECA. And for that reason, it held that there was a fine of 140,000 was held to be reasonable and proportionate. So I now want to look at Outsourced Strategies Limited, or OSL, in which a monetary penalty of 240,000 was issued. And really this demonstrates how the ICO treats slightly more rogue telemarketing companies compared to HelloFresh. And there is also a few additional learnings to kind of come out of this decision. The fine is a lot larger, a 71% increase, and it relates to breach of Regulation 21, so unsolicited calls rather than emails or text messages. But in reality, it's the conduct that we're really focusing on rather than the method of communication. So OSL is a telemarketing company. It made 1.35 million connected calls over a 1-year period to numbers that had requested not to be called or were on the telephone preference service list. It used an external data supplier and stated that numbers were checked every 28 days against TPS and its do not call or DNC list. The ICO, however, found that checks were not made and calls were made to people on both lists. OSL sought to place the blame on the data supplier, who was supposed to screen the data. The ICO held that for an individual to override their TPS preference, there must be a clear and positive action. When, for example, we're signing up for something that's conditional upon receiving marketing calls, this won't be clear and positive. They must also demonstrate a willingness to receive marketing calls specifically, not just general marketing communications or from, say, third parties or partner organizations. It has to be specific to the organization, really clear to override that TPS preference. And the ICO also held that ultimate compliance sits with the entity using the data, not the party that provided the data in the first instance. So you can't pass on responsibility. So in this instance, the ICO found that the contravention was serious, but could have been higher. In total, 8.5 million attempted calls were made, of which a large proportion reached voicemails of TPS registered individuals. It was also held to be deliberate. There were links to another company that was previously fined by the ICO for similar conduct. I think the ICO didn't accept OSL's assertions that it sought to comply with the regulations. And there were a number of further aggravating factors in this instance, including an aggressive approach on phone calls, elderly and vulnerable people, or there'd be rather a large number of elderly and vulnerable people on the recipient lists, and repeated calls to individuals who had requested not to be called. All of that led to a larger fine, despite, say, compared to HelloFresh, despite the overall number of calls or contacts made being far less, but it was the deliberate and nature of the conduct and the slightly more aggravating factors that led to the higher fine. And there are, if you look on the ICO's enforcement website, you'll see a large number of similar enforcement actions taken against telemarketing companies for similar conduct. The final case I want to touch on is a slightly surprising example of where there was not a fine. This is where the penny appeal relates to marketing messages. So it was again a breach of Regulation 22 of PECA. There were 460,000 unsolicited texts sent over a 10-day period to 52,000 people who never provided consent. In this instance, there was no monetary penalty, just an enforcement notice to cease all unsolicited communications. The reason why these unsolicited messages were sent is that Penny Appeal implemented a database that did not include an option to to record opt-outs, and therefore anyone who had interacted with a charity over the 5-year preceding period had been contacted. So essentially they didn't obtain consent. It was just anyone who communicated with them was included on this marketing list. A further factor is actually that the ICO had been engaging with the Penny Appeal for a number of years beforehand in relation to similar conduct. And it's quite a large number of contacts and messages over a relatively short period of time. Despite all of that, no fine was given because the ICO held that it was unlikely that damage would be caused in that instance. Now, that's perhaps quite a surprising decision, mainly because of the level, and it's hard to really differentiate that from, say, HelloFresh example, where again it's hard to see how there can be harm. Reading in between lines, this is likely because the penny appeal was a small charity, but it's worth noting that in certain circumstances the ICO will issue an enforcement notice rather than a fine if it deems it appropriate. The main point to come out of, or most helpful point to come out of the penny appeal decision is the ICO reiterated its advice on electronic communications. Only email or text if someone has specifically consented to receiving emails or texts by ticking an opt-in box. People cannot provide consent as a condition of subscribing to a service. It must be freely given and fully informed, and there must be an opt-out option given, both when subscribing and throughout. And this must be acted on promptly. And finally, there must be a do not call or do not contact list. And this must be screened against every time you send an email or a text, not every 28 days, not every month, every time. And that's clear guidance from the ICO, and worth making sure that you're complying with that requirement. As again, the ICO has clearly said that ignorance is not a mitigating factor. That is everything from myself and Hannah. I appreciate that's a very whistle-stop tour of the regulations and the ICO action in this space. But thank you for attending. We hope you found what we said to be interesting and helpful. And please do feel free to contact us directly if you have any follow-up questions or queries or would like to discuss generally. Thank you very much.